लोग मुझे फोन पे एडवाइस मांगते हैं प्रो बोनो कि व्हाट इज द इशू ऑफ ज्यूरिसडिक्शन एंड लिमिटेशन। ये दोनों ही सब्सटैंशियल क्वेश्चंस ऑफ लॉ हैं इन सो फार एज टेक्स्ट इज कंसर्न्ड। इवन दो limitation is a matter of procedure, but in a contextual framework in GST law, limitation is also a substantial question of law. When we talk of jurisdiction, jurisdiction is when you find based on order passed that this is passed by an officer who is not notified as a proper officer under section 2 subsection 91 of the GST law, or who does not have the authorized financial jurisdiction, or who has not signed the order. Under these three personal jurisdiction related to a GST officer, we can claim the case the order pass is therefore without jurisdiction. And once this is declared without jurisdiction, that order has either to be annulled or set aside and sent back to the officer. The other jurisdiction is related to preconditions specified in provisions. For example, under section 65 dealing with audit. Very few of you would have noticed it, but once you read the provisions carefully, you will learn the art of creating jurisdictional issues. There is jurisdictional issues when there are certain conditions to be satisfied. Like in 65, the commissioner has to initiate the order or any other officer authorized by him through a general order. So you have to see whether the officer who is initiating and conducting audit proceedings was he authorized by commissioner, either in a specific case or generally. If you are not authorized, this audit proceedings is without jurisdiction, they will have no effect. Similarly, under section 73-74, 73-74 provisions are conditional jurisdictions that, in my view, are nothing but a reassessment of self-assessment returns filed by you under section 59. Now, what are these provisions for? Now is 74A, it's one section. If you have not paid tax or you have short paid tax, or you have wrongfully claimed input tax credit, or you have taken the refund which was given to you erroneously. These are the only three jurisdictional issues available with the proper officer. On no other ground in GST mechanism can an officer issue a notice under section 73 or 74. For example, the e-way violations. For example, you have a stock and which he wants to tax. You have an excess stock. The question of excess stock is not a question of 73-74. First, demand has to be created before you say is short paid or not paid. Or, for example, now you have sent the goods for keeping in a storage somewhere, from where no taxable supply has been made. This is again not a ground for 73 or 74. And there's a limitation that first, the show cause notice has to be issued within limitation given in 74A, and the adjudication order also has to be passed within the limitation period. Otherwise, in section 5, I believe subsection 10, all proceedings abate. So these are questions of jurisdiction. One more can be question of jurisdiction where a jurisdictional high court, say for example Delhi High Court where in Delhi, or a Supreme Court judgment has not been followed by the officers. Now, if there is a jurisdictional Delhi High Court judgment or a Supreme Court judgment, any circular, notification, clarificatory letter issued by any authority is held to be without jurisdiction. Or an officer wants to invoke section 74 for multiple years so that he can get an extended limitation for certain years where limitation has expired. Qua that year where limitation has expired, you can take a question of jurisdiction and say, sir, you have no jurisdiction, therefore drop this notice. Or where an officer conducts a multiple year audit and we all start participating in audit. So whenever audit team comes to you, and if you think a certain year audit has gone beyond limitation, that audit cannot be carried on. Because the function of audit proceedings is to bring you in a show cause notice under section 73 or 74 or 74A. So once the limitation under 73, 74 or now 74A are over, audit has no meaning. Audit notice has to be dropped. Therefore, friends, whenever you have either of these jurisdictional issues in the cases before you, always frame a question of law before the first appellate authority, before the tribunal, before the High Court, before Supreme Court, wherever you go. You have to say, yes, this order is without jurisdiction or lacks jurisdiction on the following grounds. Frame a question of law and then give your argumentative issues right in the appeal itself why you say this is without jurisdiction. Now, these are serious questions of law. So even if you have the worst case on merits, worst means you say that case cannot be won, but on jurisdictional issue, you will win. So if the jurisdictions are of two types, where there is no jurisdiction or where a jurisdiction has been assumed in an irregular manner. Limitation, he is not a proper officer, the order is not, etc., etc. These are without jurisdiction order. Here courts, including High Court, cannot remand the matter. They have to annul the adjudication order. After that, if limitations still exist, the revenue can still issue a notice. However, in case of irregular jurisdiction, where you say order is not signed, or he has conducted multiple show cause notices which he should not have done. Now there he had the jurisdiction, but the proper officer assumed jurisdiction in an irregular manner. Here the orders are not to be annulled. Orders shall be set aside, sent back to the officer to follow the proceedings as per law prescribed. Therefore, friend, I thought I will answer all of you who has put on my Facebook, on my WhatsApp, some questions on these issues. So this video is for you. Enjoy this video. Wait for more. Do write comments of such videos where you think we should be giving you more knowledge. Judgments cannot be given in videos, so it's not possible. But on these issues, you can always do research. No AI, no chat GPT. Do not follow these at all, because these sites, including Indian sites, are still half-baked in terms of Indian laws. Therefore, they also quote articles of people written by chartered accountants, advocates. There is no original research done by these AI platforms. They don't do any AI on proper analysis, because those sites are very expensive where the law is analyzed and given to you. Therefore, try to read yourself, try to Google judgments, try to read articles to appreciate the law more properly. Sushil Verma, DGST Group, signing off. Thank you.